Ms. Gilkinson indicated she had filed a motion to withdraw. So let me hear from you on that first.
Yes, Your Honor. I guess procedurally, this case, the final order was entered on July the 18th of this year. We had a 2-day trial in June. Part of that was the attorney's fees. At the end of that both parties alleged, that they were forced to incur attorney's fees. The court had listed 9/15/14 and 9/19/62 and stated that both parties shall have 10 days from the date of that order to submit its written request on this matter, and the other shall have 10 days to respond. That was decided in trial, that it would be briefed. No further hearings on the matter.
Well, did the judge say we won't have a hearing, or did she say brief?
That was what was said. It was you're going to do a brief, you're going to have 10, to respond, and that was part of the court's final order. So,
right, I see that in the final order, but was there a specific statement by the judge that we will not have a hearing on it?
I don't know that there was a specific statement, but we agreed to not have a hearing and to brief it. So at the end of the day, had I have known back in August when I filed my responsive brief, I would have filed a withdrawal right then and there, because my assumption was we were just waiting on the court's order based on ordering attorney's fees or not from the briefs of the parties, which were quite comprehensive. So when we received this notice on the, I believe it was the 10th, or no, was it the 3rd of November, I believe, on a Friday, we received the notice of this hearing. There was no motion for a hearing before the court. So defendant doesn't have a motion before the court for a hearing. They've requested attorney's fees pursuant to our hearing, and I didn't for plaintiff. Plaintiff did not request attorney's fees, but we did a responsive brief to theirs. So there is no pending motion, and my understanding was the case was closed, and we were just waiting on the court to issue an order. So as soon as I received that notice on Friday, immediately I sent the appropriate withdrawal documents, and that started the time clock. Today is the 10th day for me to be withdrawn from the case. I do believe that I have a fundamental disagreement with my client. I've also not talked to him in months. And so I'm definitely asking that the court, pursuant to Rule 4.3 and my proposed order that I emailed to Chambers yesterday, that today being the 10th day that I be allowed out of this case. But I also just want to state that, these were very comprehensive briefs, and I was just, my client was just waiting on an order from the court based on the briefs.
Okay. I'm sorry. Don't let me mispronounce your name, Mr.
Pepukai.
Say it again. I'm sorry. We were talking at the same time.
Bernard Pepukai.
Pepukai.
That is correct.
Okay. Yes, sir. What is your response?
We do not have any opposition to Ms. Gilkinson withdrawing, but if she is permitted to withdraw, we just want to proceed with today's hearing, one way or the other. We are ready to proceed. I can't say whether or not I have an independent recollection of whether or not we were or weren't going to have a hearing. I can say I initially assumed we were not going to have a hearing, and it was just going to be decided on the brief, but I can't indicate whether I have an independent recollection. I don't oppose and I don't contest her withdrawing, but we are ready to proceed regardless. The petitioner in this case, who was originally considered the petitioner for this particular case, he should be ready to proceed. And we ask that one of the reasons why we're asking for these attorney's fees is because his actions has been such that it has just created, he just has been non-compliant with anything. And we just request that we resolve this. We have exhibits that we presented to the court or delivered to the court with regards to this particular issue, and we just want to make sure we just get it resolved, because we're afraid that he may avoid reappearing or may do something. So while we have him here, we just want to handle it. don't oppose Ms. Gilchrist's motion, but we ask that we just move forward regardless of whether or not she's representing him.
Okay, thank you. Let me just touch bases with the court staff before proceeding. Just stand by. Okay, thank you. Have had an opportunity to look at a couple of the orders and talk with the judge's staff, and we will go ahead since you've been noticed for the hearing and proceed today. But with respect to the notice of withdrawal, I need to confirm, Mr. Is it Vogan Thaler?
Yes, Your Honor.
And you did receive notice from your counsel of her intent to withdraw from the case?
I did.
And you did receive the further information in there about what your responsibilities were with respect to representation in this proceeding?
I don't recall specifically in terms of actual representation. One of the challenges that I've had due to...
Okay, hold on. Let me just pull it up. Did you submit your actual notice that you sent to your client, Ms. Gilkinson?
Yes, Your Honor. My paralegal scenario emailed him all of that the day that it was sent to the court.
Okay, let's see. I see the request for withdrawal, but I don't see, and I may be just overlooking it, your actual notice to him. Did you attach that?
Let me see.
Your Honor, if I may,
Yes.
I see the notice, the motion, and the certificate, and the notification of certificate all filed November 6th.
Okay, I see those, but without opening each one, is one of them the actual notice or letter or email to Mr. Vogan Thaler?
Yes, ma'am, the very first pleading that says notice, it's notice
Okay.
of request to withdraw as attorney of record for the plaintiff, mailed to him in US mail and email.
Okay, then let me pull that up. Notice of withdrawal, that's the very first one
Yes, ma'am.
in Odyssey. Okay, let me pull that one up. Okay, yes, thank you. I do see that. Yes, I will note that we'll just use this as court's exhibit 1, 2-page document to Mr. Vogan Thaler indicating that paragraph 3, you have the burden of keeping the court informed, respecting where notices, pleadings, or other papers may be served upon you. Please note, well, you said, please note that as of this date of this notice, there are no scheduled hearings in this matter. You have the obligation to prepare for trial or hire other counsel to prepare for trial when a trial date is set. If you fail or refuse to meet the above burdens, you may suffer adverse consequences. And then it goes on to give that information. So it does say no date has been set, which is clearly incorrect information, as the notice was the reason that the request to withdraw was submitted, correct?
Yes, Your Honor, I see that. I'm looking at the email in which we sent Mr. Vogan Thaler at 12:40 p.m. on the 6th, and attached to that was the hearing notice as well in that attachment.
Okay, so Mr. Vogan Thaler, you were aware of this upcoming hearing on that same date by way of email?
I'm not aware of it by email. There was, like I said, there was some confusion as to whether or not this would proceed based on the fact that because we had agreed, or at least the perception was that we had agreed on briefing only, that there would be no motions.
But whether there was confusion about that or not, though, you did receive the email from Ms. Gilkinson with that information. The only question was whether we actually needed a hearing, though, correct?
Yes, but I'm looking through my emails right now, and I don't know specifically. Like I said, we've been out of contact. I've been having some health issues. I've been out of
let me stop you there. Did you get
Yep.
the notice in the email, Mr. Vogan Thaler?
I don't recall if I got the notice via email.
Your Honor, I'd be happy to send it to the court with the email with the 3 attachments that my staff sent him, showing
Okay,
the
if
notice.
you
of
would
today's
just make that
hearing.
a part of the record.
I will do that. Yep.
That was on the 6th.
It was November the 6th at 12:40 p.m. and it came from Scenaria McGarity. It was sent to Mr. Vogan Thaler and I was copied on it.
Okay,
I'm
thank you.
going to take a picture of that and redact, though, the portion that I don't think, the court shouldn't know the reason for my withdrawal. Obviously, that's not pertinent. So
Okay,
I am going to take a picture of that where you can see the notice attached from the court. And if you could give me just a brief moment so I can confer with my staff and have them send it over, if that's okay.
that is fine.
Thank you. One moment.
Because I may need for you to simply remain. I will grant your request to withdraw given your fundamental difference. And that's the only reason I'm doing it. But I would ask you to remain in case you are needed as a witness or anything of that nature.
Okay, that's fine, Your Honor. Can I just briefly go and do this and handle
Yes,
this
you
real
may
quick?
do that.
Okay.
And
I'll be right back.
Okay. All right. Since she is not representing Mr. Vogan Thaler any longer, we can go ahead and begin.
Your Honor, I have a
Yes.
question.
Yes, sir.
I don't even have documents to proceed in this instance. Like I said, the conversations with my attorney were limited. I've been in and out of the hospital. I would ask the court to grant a brief continuance. I did reach out for alternative legal representation, and the first appointment I was able to secure on short notice was the 28th of this month. But like I said, I have no documents. I don't even have my complete file in order to be informed enough to proceed. That hasn't been provided to me.
Okay. We'll wait for. Yes, Mr.
I'd like to respond to that. We would oppose any continuance. Quite frankly, this is why we're here today, because this has been his game plan from day one for the last almost 3 years, or 2.5 years, or whatever it has been. He has intentionally delayed, postponed, made false statements, has said and done whatever he could.
Yeah, Your Honor, I object to this characterization. None of this is true.
Okay, hold on, let him finish.
None of this is true.
Okay, hold on, let him finish. Go ahead.
That's exactly what we're going to show. That's what we showed at the trial on June 20th and 21st, a 2-day trial that probably shouldn't have taken more than an hour. That's what we intend to show again today. That, so we, regardless, we, as it relates to the June issue, we also previously wanted to, there's compliance issues that goes hand in hand for this request for attorney fees. So he knew about this date. He could have had alternative counsel if he so chosen. It's not surprising that he has made this request because this falls in line with the last 2.5 years of litigation concerning this thing.
Okay, thank you. Okay.
Yeah. Am I able to respond to that?
Very briefly, and then.
Yeah. I mean, most of what was said is not true, as is indicated in this. That a lot of the aspects of the case, particularly the ones that he's referencing, compliance issues, have no bearing on this case, are completely outside. It sounds like Mr. And I'm sorry, I should be able to know how to pronounce his name a little bit better with a last name like mine. But in regard to Mr. Pepekai, those aren't relevant issues before the court. I've never avoided a court date. I've never stalled a court date. I've worked at the behest of my attorneys and guided by my attorneys. And the last thing I wanted to do was to delay this or protract it, principally because the issue at hand was access to my daughter, which was not allowed for more than 3 years, in addition to the other things that were alleged in the hearing.
Okay.
Contempt file.
Then hold on, Ms. Gilkinson, have you provided Mr. Vogan Thaler with all of his documents?
Your Honor, I entered this case 48 hours before the trial date back in June. I received everything from Mr. Vogan Thaler then. Mr. Vogan Thaler has given me everything. Anything we've received from the court or opposing counsel have been forwarded or sent to Mr. Vogan Thaler. So I don't keep a physical file.
Okay, all right, thank you. Then we will proceed.
And she's emailing that to Chambers now.
Okay, thank you. And be sure to copy Mr. Vogan Thaler on all communications.
The only thing I will, in the interest of full disclosure, I did send some exhibits to this hearing, but I sent them to Ms. Gilkerson. I can either have my paralegal send the link to Mr. Vogan Thaler directly, or Ms. Gilkerson can send those exhibits to him.
How many exhibits are there?
There are exhibits A through J, I believe.
A through J, then what might be more expedient, because the court has not reviewed them, is to just share screen and we'll all look at it at the same time.
That is absolutely.
If we were in court, okay. All right, so let's do that. So you may, are there any additional opening remarks?
Yes, Your Honor, would you like this hearing to proceed in the same manner on argument similar to your previous hearing that you held?
I don't expect for this to go on like that. So please make it concise. Yes. This case does not have a lengthy hearing history comparatively speaking, so we're not going to drag this out.
Yes, Your Honor. I can make this very concise by argument versus client on the stand. If that will speed things up, and I don't anticipate it having to be like the last hearing, assuming that we don't have to go through all the formalities of everything.
Okay. All right. So you do not need to make an opening, is what you're indicating?
Yes, I would like to make if we're going off argument, just argument.
I'm going to need evidence. It's a regular hearing. What I'm simply saying is we're not going to waste time with extraneous information that is not relevant to the issue the court must decide, but I need evidence.
I would like to make a brief opening.
Okay.
Your Honor, just briefly opening. I just want to bring to your attention, Your Honor, this is a petition started as a petition for modification in custody, modification of custody and contempt that was filed by the petitioner, Mr. Vogan Thaler. However, Your Honor, just to give a little bit of background, that petition was filed after a previous petition by my client was filed for contempt against him. However, it was never served on him because he has always avoided service. So one of the issues as it relates to the fees that are associated in this case, and we are requesting fees pursuant to 1993G, 1962, as well as 91514. But one of those reasons that goes behind that is because of the difficulty that has been associated with every aspect of the case when dealing with Mr. Vogan Thaler. So initially it was a contempt that my client had filed, and she had previous counsel, but he was not able to be served. Then he was served. What we would simply show is, and that what was shown during the trial was simply that the bulk of the allegations that he made was just simply false, and it was drawn out. It created a lot of work. As a result, my client incurred over $70,000 in fees, legal and otherwise, as a result of this action that were totally unnecessary, and we're asking for that to be reimbursed. Even after the hearing on June 20th and 21st, part of it had to do with child support as part of the contempt. He hasn't even paid, he hasn't voluntarily paid one voluntary child support payment since the—
Okay, that's irrelevant.
Yeah, objection.
Well, it's part of this proceeding, just to give you—
Objection.
Okay, well, I've ruled on that. He hasn't finished a sentence, sir.
Sorry, Your Honor, there's a delay in hearing.
But nevertheless, what we just want to show are the fees associated with this case are solely as a result of unnecessary delay, the difficulty and unreasonableness, and just in many cases, just flat out falsities that were filed that were determined by the court. If you read the court's order, there were some things that were just plainly false, just plainly false. And as a result, my client accumulated substantial legal fees through no fault of her own. And we're asking them to be reimbursed pursuant to 1993G, pursuant to 1962, and pursuant to 91514. Although the court's order does only identify 1962 and 1915-14 as it relates to submitting a motion, I will submit to Your Honor that Your Honor has discretion. The court always have the discretion to award fees pursuant to 1993G. And those fees were previously requested in previous proceedings. So that is something that the court does have discretion to consider as well.
Okay. Brief opening, Mr. Vogan Thaler.
Yeah, just to counteract some of the misperceptions and miscasts of this case is that by and large, this case went on for quite a long period of time because there was intransigence on the part of the defendant in this case. At any time, she could have ended mediation, which is the very first stipulation in our decree, which is to essentially effectuate mediation. She declined that. She refused that. There were several attorneys that had changed. And then what ended up happening with COVID and everything else is that is the reason why this case got prolonged. There was nothing frivolous in this filing. What opposing counsel is saying is just flat out not true. And I'll demonstrate some of the things that occurred in the case where we were both found in contempt as a result of this trial.
Okay, thank you. You may present your evidence on behalf of the movement, and we're not going to retry this case. Let me make this very clear.
No, I understand. I understand.
We're not going to retry this case.
No, I understand. So, Your Honor, just to give additional context,
I'm sorry, I thought you were finished with your opening.
Oh, I am. I thought you were I thought I was moving into.
No, he's the movant. They're the ones moving.
Oh, he is. Okay. Fees. All right. So I'm sorry, Your Honor, because I'm not familiar with procedure.
Okay, well, hold on.
How much time is allotted?
You said you were finished with your opening, so it is their time now to present to me what evidence they have.
Okay. All right. That's what I was asking.
Your Honor, at this time, I would like to call Ms. Yumi Toka to the stand.
Yes.
Ms. Toka, do you swear that the testimony you will give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Your Honor, I am, Ms. Toka, what I am going to do is share with you my screen. Who was your first attorney in this matter? The Aaron Thomas firm?
Yes.
And in the motion that was previously submitted, there was an affidavit by Dale Cheka. Can you see that signature right there?
Yes.
And there were bills associated with the Aaron Thomas firm, ATL right here, and the bills that were associated with it were submitted in the motion. Were those bills, legal bills that you paid to that firm to represent you in the matter against Mr. Volkenheimer?
Correct.
Volkenheimer? Your Honor, I'd like to move that to be accepted into evidence.
Well, Mr. Vogan Thaler, any objection?
He's on mute.
You're on mute, sir.
Sorry. I'm just trying to understand the relevance of this. Where both of us have incurred significant
okay, so that's not
attorney's fees in actual amounts.
Do you object to the affidavit that has been submitted?
I haven't.
Itself.
Yeah, I haven't reviewed the affidavit, so I'm assuming that it is a bill, and that's all my understanding is of it.
Okay, well, take a minute to look at it so you can let me know whether you object.
And I will note that this is the same affidavit and bills that were submitted in the actual written motion that I'm certain that he would have received. Ms. Gilkerson is here, and I would be certain that she forwarded him a copy of the written brief. He did file a response to this.
Okay, you're going far beyond where you need to, sir. Just let him take a look at it. If you need to scroll, you need for him to scroll up or down.
I
Sir,
will-
just let us know.
David.
Yeah, I mean, I can see it. I can't see it in any great detail. I acknowledge that it is a bill. My
Okay,
only
again,
question
take the
is,
time as
yeah,
if it were in front of you to look at it. Go to page 1 of that document and let us know when you finish reading it.
I don't think I can control of the scrolling through the document.
No, just
Am I?
that's what I'm saying. Let us know when you're finished with page 1 and then we'll go to page 2.
Okay, I have a question about page 1, if I may ask a
You
question.
don't have can't ask a question, simply
Okay, all
let
right,
me know when you're
sorry.
finished.
Okay, you can continue to scroll. Okay, next. Okay, just based on what I see, I don't have any objection to a bill.
Do you have any objection to the affidavit with the bill attached?
Could you, the affidavit being the first part, I think.
Yes, yes, sir, the first part.
If we could go back to it, I'm sorry. I have no objection to the affidavit.
Okay, exhibit A is admitted without objection.
After you hired the Aaron Thomas law firm, did you subsequently hire the law firm of Heredia and Lennon?
Correct.
And was that attorney, Ms. Ashley Heredia, that you hired on your behalf?
Yes.
And I am going to show you what has been marked as Exhibit B. And you see that affidavit of J. Ashley Heredia, Esquire.
Yes.
And are these the bills associated with the representation that you provided to you?
Yes.
I would like to have this admitted into evidence as Respondents B.
Okay, so we'll do the same thing. Scroll back up to the first page. Mr. Vogan Thaler, let us know when to scroll to the next page.
Your Honor, I don't know. Like I said, I'm lost in this process, that I don't know what constitutes an objection to something regarding a bill. I'm assuming it's an actual bill. I don't have any objection to it.
You don't have any objection to, did you say this is B? I can't see it. Is that B?
Yeah, I'm assuming it's a B. It's a bill in an
Okay,
affidavit.
so you have no objection to that, is what you're saying?
No.
Okay, then B is admitted without objection.
And then after you hired the law firm of Heredia and Lennon, did you hire the law firm of Hedgepath Heredia
Yes.
and the services of MIG?
Yes.
And did you pay legal fees as it relates to those services?
Yes.
And I apologize, but I'm having a delay in my document coming up. And I am getting ready to show you my screen. And it's an affidavit actually attested by me. I can also represent to the court the contents of this affidavit. But more importantly, for purposes of you, is these bills that either you have paid or will be billed from the law firm of Hedgepath Heredia.
Yes.
Your Honor, at this point in time, I would like to ask for these to be admitted into evidence. Let's see.
Okay, any objection, Mr. Vogan, Thaler?
No objection, Your Honor.
C is admitted without objection.
Now, Your Honor, I would like to turn your attention to Exhibit D that I submitted to the court. And I would like to present this to the court as a demonstrative exhibit as our Exhibit D that reflects the total of those invoices from the 3 firms. Can you see my screen, Your Honor?
Yes.
And I would like to have this submitted as a demonstrative exhibit.
Sorry, you mean if it's a demonstrative aid, then
Yes. Yes, so I'm requesting to be admitted.
Mr. Vogan Thaler, any objection?
I don't have any objections.
Hey, $68,220, then it's admitted with no objection.
And I would like to now bring your attention to Exhibit E. And these Exhibit E is also a demonstrative exhibit that outlines within those 3 firms the fees specifically associated with 9, 15, 14 fees. So I will represent to the court that on the left side is the date that the item was billed. It also has the section that we're proposing that it's applicable to 19, 15, 14, whether A, B, or both. The issue that justifies the 19, 15 fees, the amount of the fees incurred.
Sorry, is this enclosed in your brief?
This is not. The fees are, but not the demonstrative exhibits.
Okay, so a demonstrative aid is typically not actual evidence. So for purposes of just demonstrating the point that you're making, that is perfectly fine, but this is different than just a total. I had a question really about the other demonstrative aid that just basically totals everything. I did let it in. So certainly you can utilize this, you can share it, but as far as an actual exhibit, I don't think that's appropriate.
Okay, Your Honor. I was just, when Your Honor makes Your Honor's final determination.
I may ask for a follow-up brief or something of that nature. And if you wish to include it as just a demonstrative aid to that or a summary, but this is not appropriate as an exhibit for the court, I don't believe.
Okay.
Your Honor, I'm sorry, I have a question.
Yes, sir.
For the court. Am I able to object to this document?
I just said it's not going to be evidence.
It's not.
It's not evidence.
Okay, great. Because I would just.
But if there is an opportunity afterwards, it's certainly fine to summarize the evidence in this fashion, and you may have an opportunity to do that. You may have an opportunity to submit something of your own, but just as far as summarizing it and demonstrating it, that's not typically an actual exhibit to be considered.
Now, Ms. Toka, I'm going to ask you a couple of things as it relates. Did you recall you initially filed a contempt petition against your ex-husband?
Correct.
And why didn't that contempt petition go be
I didn't have his physical address, and he is not living in Atlanta, so I didn't know where he is.
You tried to get his physical address from?
Excuse me, I'm sorry.
Did you
Okay,
try?
in order to just go through this, that typically is not a reason. A defendant does not have to give you his or her address. So I'm just going to remove that off the table in the interest of time, because that's really irrelevant.
I understand, Your Honor, but if I can just explain, one of the things that I'm trying to demonstrate to Your Honor is then for the 1915-14 fees, I'm identifying the specific places in the bill to point to Your Honor, considering for these fees. We're asking fees under a couple of different sections. One, we're asking fees under 1993G. Alternatively, we're also asking fees under 1915-14.
I understand that, but someone not telling you where their address is irrelevant to any of that.
I know, but under 1915.
Please move on.
May I make my statement for the record, Your Honor?
You may make your statement for the record, such as it is.
Yeah, I'm just for the record, the purpose was under 1914-15B, one of the characteristics is intentional delay.
Intentional delay has nothing to do with a defendant not voluntarily giving up an address. The court will not make that leap. So let's move on.
Thank you, Your Honor. Ms. Toka, did you, after the hearing in June, did you attempt to, one of the issues that were discussed was issues related to your tax. Is that correct?
2017 tax.
The 2017.
Yes.
And those taxes was discussed because.
Your Honor, I'm objecting to this. This isn't even germane to the hearing that we're discussing. I think attorney is trying to shoehorn a contempt action within a motions for attorney's fees, and it's inappropriate.
Okay, response.
Your Honor, this whole thing, what I'm trying to show, I can do this in argument. I don't need necessarily my client to testify to certain things, because certain things is an argument in fact when it's already in the record. The reason why I'm having my client testify, because Your Honor indicated that you, at least I thought Your Honor was indicating that you wanted testimony to get the exhibits that I'm presenting to Your Honor and to evidence. That's the only reason. But I would submit that that's not necessary. So that's why I was going that route, because the bottom line is these things are in the record. They're already in the brief. They're in the pleadings. Besides some of the exhibits that are subsequent to the hearing that also goes to the delay, or that goes directly to the 1915 fees and the reason why, in the interest of equity, these fees should be assessed to.
Hold for just one moment.
Can you see this?
Yes.
And what is this?
This is for the tax lawyer.
And
Your Honor, I object to this. This isn't relevant to this hearing. This is, again, Mr. Papayaki, and again, I apologize. I hope I got it right. This isn't germane to this case.
Let's stop.
Trying to shoehorn. He's trying to shoehorn a contempt hearing into this case.
Let's do this. Y'all have been together in this case for how long? And every time we call someone's name, we're not going to say, I should know how to pronounce their name. So.
Oh, I'm sorry.
I'm not going to keep doing that. So let's go ahead and move forward. Your objection is what, sir?
My objection is none of this information that's being presented is germane to this hearing. We are here to discuss attorney's fees. This is a motion for attorney's fees, and this is not something that is germane to this case.
Okay. What's the response?
Again,
okay, hold on.
Your Honor, this is actually a motion for all fees. This is what we're talking about. And part of the fees are the fees associated with the tax issue that was part of the original.
Okay, overruled. You may continue. Yeah,
I'm sorry.
He moved to, did you admit it? Did you move for admission yet?
I haven't moved for admission, but I am moving for admission now.
Okay.
I will admit this as Exhibit F.
and Mr. Vogan Thaler objects on the grounds of relevance, I'll overrule.
I object, yeah, well, Your Honor, I actually object on relevance, but I also object on the fact that this is outside of the scope of even his brief. These fees that he's trying to shoehorn in here happened after the trial. These aren't even part of his original brief. This
Okay,
is just
well,
the backdoor way of him trying to shoehorn a contempt
Hold on,
issue.
then you can argue that it's beyond that time, but the court will find that it is relevant. And you can make that argument at the appropriate time. Or question her about that. You may continue.
Okay.
Thank you, Your Honor. And Ms. Toka, are these the fees directly associated with the court order? That the
Right,
fee,
related to 2017 tax.
yes. Next, I am going to show you what has been identified as Exhibit G. Can you identify this document?
Yes,
What is it?
this is additional fee. The previous one is a retainer, and this is a final fee.
So you paid the $2,500, and this is the amount that's remaining on this tax.
I haven't paid it yet.
But this is the amount that is remaining.
Correct.
Your Honor, I would like to admit this as Z.
Yes, any objection?
Yes, I object for the same reasons that this is outside the scope. This is a backdoor attempt in him trying to shoehorn this into a contempt hearing. None of this is referenced in this brief. And the fact of the matter is, I've never been presented with these bills to be even able to resolve them after the fact. None of these are mentioned in his brief and are inappropriate.
Okay, then I will overrule the objection, and the appropriate questions and argument can be made at the appropriate time.
Thank you, Your Honor. Next, Ms. Toka, I am going to show you what has been marked as Exhibit H. Do you recognize this email correspondence from Lloyd Mahoney?
Yes,
And who is Lloyd Mahoney?
he's one of the tax lawyer counsel.
And is he the tax counsel that worked on your 2017 tax issues with Mr. Volkenheimer?
Yes,
And is this correspondence to you outlines the amount of taxes that are due or were due for the 2017 tax year? That was an issue in this case.
correct.
Your Honor, I would like to admit this as Exhibit H.
Any objection?
Your Honor, I object to Exhibit H because this is hearsay, because this is a statement from an attorney.
Okay, response?
Your Honor, this case specifically deals with fees. And what Her Honor ordered in her order is for these fees to be allotted a certain way because he's responsible for them in Her Honor's June 20th order. This outlines the percentage of what the responsibility for those fees are. And only this can come from the tax lawyer because the issues that were involved with the tax.
In the court, I will sustain the objections. That goes far beyond the scope of this hearing.
No, but the contempt and the
Court has ruled.
Ms. Toka, I am going to show you what has been marked as Exhibit I. Do you recognize this document?
Yes,
Does this reflect the amount that you paid to the IRS for your 2017 taxes?
correct. That's a joint
Let me ask
penalty.
you this. I'm sorry, how is this relevant to the attorney's fees?
Your Honor, I'm trying to explain this is relevant to fees. So the fees include tax fees as well as attorney's fees. Taxes were a big issue and a big.
Doesn't matter, there's a big issue. This is for attorney's fees.
We're
If
Yeah,
there's
Your
other
Honor.
issues, that's beyond the scope of this hearing. This isn't about every fee and everything that was generated from the underlying hearing. This is an attorney's fees motion in hearing. So I would not admit, was it J? Is irrelevant.
Thank you, Your Honor. Your Honor, that is all I need my client to admit. The rest, I would like to refer to the documents and the arguments to give Your Honor context of why these fees are necessary. So I don't have any more admission documents for my client. The remaining is primarily argument to reflect on the brief that has been submitted, as well as to put it in context for Your Honor, to get a context of why 1993 G fees are appropriate, as well as 91514 and 1962 fees are appropriate.
Okay, you may examine the witness, Mr. Vogan Thaler.
Okay, thank you, Your Honor. Ms. Toka, did you ever agree to mediation in this litigation?
It's been too long. I really don't. I mean, I don't recall. I don't remember.
Okay. All right. During the trial, I'm sorry, let me back up a minute. Can you state for the court what your annual income is?
Okay, what's the relevance?
The relevance, it goes to some of the factual basis in case 1962.
The relevant incomes. Okay, go ahead. You may continue.
Do you need me to repeat the question?
Go ahead and answer, ma'am.
The current income,
What is your total income, including salary, bonuses?
168,000.
And that's the total.
Yes.
Do you receive any bonuses above the 168,000? Any stock options? or
Depends.
grants?
I don't have a stock option.
Okay. Are you aware that your attorney has billed you 13.2 hours for this hearing? For a 30-minute hearing? Are you aware that he has billed you almost 14 hours for this hearing?
I don't know.
So you're not aware
I'm
that
not
he's
aware.
billed you that?
Your Honor, I would object.
He submitted
Okay, hold
the
on.
invoice, Your
Hold
Honor.
on, let him place his objection. What's your objection?
Okay.
I would object first on a couple of things. One, she asked and answered, but two, in addition to that, the documents speak for themselves. We have already submitted the bills for the attorney's fees. They're entered into evidence, and Your Honor can view them as Your Honor may.
Overrule. Answer the question, ma'am.
I don't know.
Do you find a billing rate of 13.2 hours for a 30-minute hearing excessive?
Your Honor, I object. Cannot determine, that would draw for a legal conclusion, someone to understand what goes into.
It's an invoice that he submitted
Okay,
to
hold
the
on,
court,
let
Your
him
Honor.
finish. Do not interrupt. Go ahead.
Sorry.
A layperson can't reasonably testify as to the reasonableness of attorney fees.
I'll overrule. You may continue.
Your Honor, I'm not sure, did she answer the question? Do I need to rephrase it? I don't know if I've gotten an answer.
To be rephrased. Answer the question, ma'am.
This is really a long time accumulated information that he needs to overlook at it. So, even though 30 minutes, but probably he needs to go over some of the points. And it's a lot of information. So excessive, or I can't really determine that.
Okay. So your statement to the court is you do not find 13 hours to be excessive. Okay.
Your Honor,
I can't call. I
Object.
can't call.
Okay. All right.
Okay, I'm sorry,
I'll move on.
what's your
I'll move on.
I'm sorry, hold on, what's the objection?
ask and answer.
She has to say yes or no, she may explain her answer.
Well, Your Honor, she answered the question. He
Do
just,
not go back and forth with the court. If she can say yes or no, she did explain it, but she did not say yes or no. So is that yes or no, ma'am?
I'm sorry, so repeat the question again? It wasn't a yes/no question, I don't think.
Repeat
Okay.
the
The
question.
question was for a 30-minute hearing, do you find 13.2 hours at, I'm not familiar what his rate actually is, 13.2 hours to prepare for a 30-minute hearing, do you find that excessive? Yes or no?
It's not yes/no question, I don't think.
Now answer the
I-
question.
I can't
Answer yes
answer
or
that.
no.
I'm not this professional enough to understand how long it will take.
Okay. During the contempt hearing, was your modification denied?
Your
You had
Honor,
requested a modification of
Sorry, what's
custody?
your objection, Mr. Pepakali?
relevance.
I'll overrule.
The relevance goes to
I've
the
overruled.
attorney fees.
Continue.
Yeah.
Continue.
Okay. So, were you found in contempt of any articles of contempt during the trial? Were you found guilty of any articles of contempt during the trial?
Only one,
And what was that?
that I didn't disclose Kate's phone number. Or social media, I forgot.
Did you disclose the email, which was also required to provide to the plaintiff, to me?
Yes,
Yes, I'm sorry.
yes, I have.
Were you found in contempt? I guess if I need to rephrase it to clarify, Your Honor, I'm sorry, I'm not new at this, but were you found guilty of contempt for not providing the phone number and the email address and the social media accounts?
Your Honor, I object. It's a compound question, and he already answered two of those things. And he didn't like
Okay, then we'll just,
half of the third, so he tried
Okay,
to.
then just saying it is one question with three parts. So if we need to break it down one by one, we can do that. But go
all right,
ahead.
Your Honor. Yeah, she's answered two of them. So the question, I guess, that was not answered is, were you also found guilty of contempt for not providing the email?
Your Honor, I object. An order speaks for itself. We have like a 20-page order on this.
Your
Okay,
Honor, I
sure.
mean,
Okay, hold on. Please stop objecting based on his questions. I mean, this whole thing, we have an order, right? So let's give him ample opportunity to cross-examine her. You put her up, so let's give him an opportunity to examine her on relevant items.
okay. Nothing further with this witness, Your Honor.
Okay, other questions for your client, sir?
The only question I have is, I don't have any questions. I just want to make my legal argument based upon the circumstances of
Okay.
this time.
I understand you. I'll give both of you an opportunity to make a closing argument, but right now, do you have any more evidence?
Nothing outside of the fees in the bill shown. The fees in the bill shown and the things that are directly applicable to this case that I presented to Your Honor, that's it. everything else.
I'm sorry, I don't want to just belabor it, but I'm going to give you an opportunity to argue based on whatever evidence that has been presented. I'm just trying to make sure that you presented all of the evidence that you intend to at this juncture.
The only thing that I would ask is the evidence when, Your Honor, as it relates to Exhibit H and I, the IRS debt and the tax and IRS issues that you did not admit, I would submit to Your Honor that they are directly relevant to these cases. That's the only thing I would ask for reconsideration. Other than that, I don't have any other evidence. It's all argument going to those issues that are directly related to this case and this contempt and the issue of attorney.
Understood. The court will not reconsider its position. In fact, I am actually pondering the relevance of F and G, but I will address that. Any evidence, Mr. Vogan Thaler?
Evidence in this case?
On the motion for attorney's fees only.
Any additional evidence? Well, I mean, the evidence by and large is that most of the accusations that are being mischaracterized in this,
you're making an argument at this point. Do you wish to make a statement? If so, you'll need to be under oath.
Okay, I don't wish. Yes, I would like to make a statement.
Okay.
Your Honor?
Yes.
I'm sorry, I didn't mean it. I would like to ask my client a couple questions if I could.
Well, hold on. You told me you didn't have any more. I've moved on to him. If there is rebuttal, then I'll give you that opportunity. But we're not going to keep going back and forth. We're going to maintain order during this hearing. Okay, so go ahead. Let me place you on oath. Raise your right hand. Mr. Vogan Thaler, do you solemnly swear or affirm the information you shall provide shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, go ahead.
Your Honor, I guess the general theme with this entire case is that both modification and modification was denied by the court. Both of us were cited with contempt. As far as the income disparity, Ms. Toka makes $168,000+ a year. I don't make anywhere near that amount. I make about $65,000 a year. There's a huge income disparity. I would not, and I did not take frivolous action in this case. I went on advice of counsel, which, you know,
Please continue, sir.
Yeah, if you could bear with me for a second, my computer is freezing up. So I think by and large that this hearing was brought in the very beginning because I was denied access to my daughter. And in this case, it was nearly 3 years before I was even given access to my daughter in this case. But there ultimately are several reasons why she shouldn't get attorney's fees in this case. One is the income disparity. Two is the fact that she also was convicted of contempt. I mean, let me start again, Your Honor.
Well, don't start again. No, sir.
Yeah.
Keep moving.
So, I mean, essentially, Your Honor, I mean, this case, the primary reason for this contempt action was because I love my daughter, and this was acknowledged by the court during the trial. This is the sole reason why this action has been brought. I did not have access to my daughter. I was kept away from her intentionally. And the issue is, I'm trying to live and have tried to live a meaningful life with my daughter, but again, it was denied. For more than 3 years, I was denied communication. And
Okay, now that's beyond the scope of this. I don't believe just that rehashing all of that is not necessary, so please move forward.
okay. All right. Well, that's basically the entire reason why this case was brought. And as a matter of fact, I mean, the firm that I initially employed, which is Richardson, Bloom and Lyons, they're far from people who waste time, who are frivolous in their actions. In fact, one of the reasons why I went with the firm in the first place is, I didn't have any money. I don't have the same level of income as Ms. Toka does, and I certainly didn't then. And I went with Richardson, Bloom and Lyons to, obviously, first and foremost, to reconnect with my daughter. And their approach to all of this is collaboration, is not being frivolous, not being vengeful. And they did everything by the book. They're a reputable firm. And I certainly didn't have money to spend on wasteful actions because there's a huge income disparity. Most of what I've put into this case is the little amount of money I had and borrowed money from families and friends, which still needs to be paid off. This was not a case that was protracted by me in any way whatsoever. I would have preferred a mediated solution in the very beginning, and that was never a part of this case. I do know that my attorneys, given that that is their approach of collaboration and mediation, had requested that several times, and it was thwarted in every event. So I think the idea of this, the general tenor or accusation of somehow my litigation is somehow vexatious, or I don't remember the name of what he said. I was accused of elongated litigation. I don't control the court calendar. I don't control what my attorneys do. I'm guided by what they do. I'm guided by the direction that they give me. But there's nothing frivolous or vexatious or elongated about this case. This continued accusation is false, if not nonsensical and ridiculous. And again, just to reemphasize, I did this to be able to have contact with my daughter, which did not happen on any sort of regular basis for 3 years.
Okay, questions of him on cross? You're on mute, sir.
I'm sorry?
I told the attorney he was on mute.
Oh, sorry,
Mr. Vogelheimer,
difficult time.
you indicated you made $65,000 a year now.
Approximately, yes, less now.
What is the most you ever made?
I don't, off the top of my head, I don't know.
Isn't it true you were making 175,000 plus before?
When was that? That's not true.
You never made 175 or more?
I don't recall making $175,000. If I did, it would have been more than 20 years ago. At the time of the trial, to answer your question, at the time of the trial, it was less than $100,000.
Mr. Vogelheimer, isn't it true? Can you give your address to the court, please?
I'm sorry?
Physical address. Can you tell your physical address to the court and to Ms. Toka?
I've already provided that to the court on 2 occasions, and it still remains.
You haven't. Can you state your physical address, please?
Your Honor, what is the relevance of my physical address? This isn't a relevant line of questioning.
Relevance?
Your Honor, this goes exactly toward the attorney's fees. The point is, he has been difficult every single step of the way. He has never even provided his physical address to execute custody. And for him to file a modification of custody, He has not paid one single
Okay.
child support payment.
What, Your Honor,
Well, okay,
relevant-
hold on. So, that I guess can be relevant. So, answer the question, sir.
What is the question?
What is
What
your
is your address?
address?
I don't, at the moment, I don't have a permanent address. I am in the process of finding housing in
You have
Atlanta.
never provided a permanent, a physical address to Ms. Toka.
That's not true.
What is your physical address?
I don't have a physical address as of right now.
No further questions.
Okay. Any further statement?
No, I mean, I'm in transition. I was working in consulting, which required 100% travel. And I want to be closer to my daughter. So next week when I'm in Atlanta, I intend to further my search for housing. And not to mention, Your Honor, over the last couple of months, I've been in and out of the hospital, which is for cardiac issues, and it's really slowed down my ability to conduct and complete my search in the Georgia area. So right now, I mean, I spent most of my time kind of in and out of a hospital and in and out of hotels just due to my job. And I'm looking to change that.
Okay. Additional cross of him?
No additional crosses. No.
Okay. Mr. Vogan Thaler, do you have additional evidence other than your statement?
No additional evidence, no.
Okay. Any rebuttal?
Yes, Your Honor.
Okay.
Ms. Toka,
Yes.
in the petition for divorce that he filed against you, not divorce, I apologize. In the petition for contempt and custody that he filed on June 2nd, 2021, in his count, he indicated that you withheld your child from him. Was that factually accurate?
No.
At the time he filed his petition that stated that he withheld your child from him for the summer visitation of 2021, where was the child actually at when he filed that petition?
She was in Ohio with him at his grandparents, one of the grandparents' house.
Objection, Your Honor. I mean, this goes to relevance. How is this relevant?
Okay. Relevance?
Your Honor, I'm showing you, and this is something, Your Honor wasn't at the trial, so I'm trying to give you a context. The bottom line is his bases were totally false. He indicated on the outset, he made statements that was just totally false. They was just not true. And
Your Honor,
wasn't.
Okay, hold on, let me finish.
Your Honor wasn't the trier of fact, so I don't think Your Honor really got it. I'm not able to give Your Honor a full context of what's really has taken place in the detail of this case.
Okay, well, the facts will speak for themselves. The order will speak for itself, the final order. And the court will rely upon the record that has been made. But we're not, again, going to go back and rehash what you all did for 2 days.
And Your Honor, my point is, we don't have to rehash it. I can do an argument, but what I'm trying to explain to you, Your Honor, is that there are certain things that he's actually.
Okay, so let's do this because you're into argument now. He objected to the question. She's answered where he was. I'll overrule the objection. Please move on.
Now, for Ms. Toka, for example, on count 8 of his original petition, he talked about, I'm sorry, back up. He talks about in one of his counts that you denied his access of complying with the court's original divorce order about Cobra. was that factually accurate that you did not provide him with the information?
Okay, again, we're not going to,
Objection, Your
we're
Honor.
not
We're
going to
returning the case.
I'm sorry. We're not going to do that. That's irrelevant at this juncture. So let's move on.
Well, Your Honor, if I can make argument to give Your Honor a context, because these are the statements, they're in the record, and Judge
Right, the
Berry has
record will
already
speak for
heard these.
itself. So
So-
do you have questions for your client that are relevant specifically to the attorney's fees issued today?
Well, all of these things are relevant to attorney's fees because the attorney's fees are pursuant to 1993G and 91514. That's why they're relevant, because these issues had no merit whatsoever.
Understood, but in order to address these motions for attorney's fees, the court is not required to go back and have you relitigate the issues that you've already litigated before the court and that have been reduced to written orders by this court.
Understood, Your Honor. I can finish everything else in argument.
Okay,
The opportunity to explain an argument, the context of all.
okay. All right, she did answer one or two more questions. Any cross of her on those additional questions? Mr. Vogan Thaler?
No questions, Your Honor.
Okay, any additional evidence? And I guess sir rebuttal at this point. Any additional evidence, Mr. Vogan Thaler?
No additional evidence.
Okay, for the movement, how do you wish to handle your closing?
I will.
Okay, no, he's the movement. You're the respondent.
Sorry, I thought you were talking to me, Your
I would
Honor.
like to waive and reserve and speak last.
Okay, go ahead, Mr. Vogan Thaler. Make your argument to the court as to why these fees should not be granted as requested.
Okay, if we could just go back to augment some of the statements I made. The primary reason for this litigation was to gain access to my daughter. I mean, for more than 3 years, custody was withheld. I was not allowed the regular access as per the order. For more than 3 years, I fought to get this, and at no time was there ever an instance where the defendant in this case provided the information that was requested. Again, that was the primary reason for this case. The mere allegations that this filing was somehow substantially frivolous or substantially groundless, vexatious or elongated is false, and if not nonsensical and ridiculous.
And I'm sorry, hold on just a second. Attorney Gilkinson, you are free to remain, but the evidence is closed, so you would not be needed as a witness, but you're welcome to remain.
Thank you, Your Honor.
Okay, I'm sorry, you may continue.
Yeah. As I mentioned, Richardson, Bloom, and Lyons were hired because their collective mantra was a solutions-based approach. I was looking for mediation. I was looking for a quick solution. And anytime that my attorneys would propose mediation, they were thwarted. This predates even the current action, just resolving things from the prior to the contempt action. She had another attorney who stalled and delayed and refused to attend mediation. And my attorneys had actually waited for more than a year before filing this contempt action against Yumi. They worked diligently to try to resolve this. There was no resolution. My attorneys worked with her attorney at the time to resolve this, and they just wouldn't refuse. There was no commitment to mediation, which is actually part of the decree, and this case just continued on. Any of these filings that were filed in this case were an approach taken on advice of my counsel. This isn't something that I'm driving. I'm looking for an ends, or a means to an end, which was, because I love my daughter, to have a connection with her, in addition to everything that goes along with that. And Your Honor, one of the considerations, and I'll leave it to the detail in the brief. One of the considerations of even determining attorney's fees in this case is the financial condition of the parties. Our financial situations are quite different, in fact, years apart. I've spent an equal, if not greater amount, as I previously mentioned, to not only move this case forward against my great reluctance, but also to defend myself from a lot of frivolous accusations as part of this litigation. Again, our financial situations are quite different. They're light years apart. The respondent earns approximately 3 times what I earn, roughly $168,000 as she testified. The respondent was awarded our marital home and has nearly $1 million in retirement funds. And with child support, that's nearly $17,000 a month. Her financial situation is not bleak in any way. I could extend, I could earn substantially more, but there are other outstanding matters regarding this that have yet to be resolved. I'm not able to pass a background check based on some actions outside of the contempt, which involved an incident during custody exchange. I have outstanding legal bills and repayments to make from those whom I borrowed for this action. I simply don't have the money. I have an outstanding balance with the IRS, with whom I'm in the process of negotiating. I've had serious medical complications in the last 3 months and have recently incurred an estimated amount of more than $28,000 in medical debt. I mean, at the end of all of this, I asked the court to deny motions for additional attorney's fees under the statute 19.6-2 for the aforementioned issues. There's further detail regarding this in the brief. I'm not privy to many of things, but the statute references, I would request that the court review those. But again, one of the bigger issues around this is that I'm sorry, I lost my place here, Your Honor. One of the issues in the brief is that the respondent fails to mention that both parties' requests for modification were denied by this court in the final order entered in on July 18th. Both parties were found in contempt of court. We were both found in contempt of court in the court's final order. Given both parties cross modification of custody being denied, and both parties were found in multiple counts of contempt of the court's final judgment decree of divorce, neither party can be a prevailing party in this situation. Stating that petitioner engaged in frivolous elongation of litigation is disingenuous, as the court clearly found merit to certain counts of petitioner's contempt, and further found neither party had proven their case to warrant modification of custody or visitation. Furthermore, the court's July 18th, 2023 order contemplates respondent having requested fees under OCGA 1962 and or OCGA 1915-14, but not OCGA 1993, which the respondent nonetheless requested fees under. The petitioner has not requested attorney's fees in this. OCGA 19-6-2 provides as per the part, the grant of attorney's fees is a part of expenses of litigation made at any time during the pendency of the litigation, whether the action is for alimony, divorce, an alimony or contempt of court arising out of either an alimony case or divorce and alimony case, including but not limited to contempt of court orders involving property division, child custody, and child visitation rights will be within the sound discretion of the court, except that the court should consider the financial circumstances of both parties. I just presented that information that the Respondent's income is nearly 3 times my income, and the respondent requests an indeterminate amount of award of attorney's fees under the 19.6-2. Respondent alleges through affidavit of her counsel, despite not testifying to an amount at the time of trial, she spent $24,203 in attorney's fees from April 2023 until August 7th, 2023 for the underlying matter. While the statute 19.6-2 allows for the grant of attorney's fees and expenses of litigation, attorney's fees and expenses of litigation are within the sound discretion of the court, except that the court shall consider the financial circumstances of both parties. The court being required to consider the financial
Your Honor, I'm sorry. I think he's just reading the brief of his counsel at this point.
That I note that is what he's doing, but I don't know that that's objectionable. Is his closing?
Yeah, may I continue, Your Honor?
Go ahead and continue.
Yeah, I'll start again. The court being required to consider the financial circumstances of the parties. The financial circumstances are as follows. Again, restating that respondent earns over $16,000 per month in her lucrative executive employment, whereas I spent 100% of my time on the road. I still owe counsel money, my previous counsel money. My income is largely commission-based, and consulting work, I earn substantially less. I did pay a lump sum of $12,000 immediately following the court's order, and still owe the respondent $5,000 to satisfy support arrears, and a monthly child support payment of $1,127. Financial circumstances simply do not compare with financial circumstances of the respondent. Furthermore, petition based on the court's orders responsible for all fees and the expenses of the parties' 2017 tax return, to include penalties and interest of same, something that I'm in active negotiation with. But based on my limited circumstances, my hospital stay, the fact that my work is commission-based, contract-based, it's financially beyond my needs, or beyond my needs. Again, she was awarded the marital residence in the divorce, and at the end of the day, I earned approximately about $4,000 per month, and that doesn't include business expenses and some of the travel expenses that may not be included. So I asked the court to deny respondent's motion for additional attorney's fees under OCGA 19.6-2 for the aforementioned reasons. OCGA 19-93 provides in pertinent part, except as provided in Code 19-6-2, in addition to the attorney's fees provisions contained herein, the judge may order reasonable attorney's fees and expenses of litigation, experts and the child's guardian ad litem, and other costs of child custody action and pretrial proceedings to be paid by the parties in proportions and at times determined by the judge. Attorney's fees may be awarded at both the temporary hearing and the final hearing. I further request respondent further requests an indeterminate amount, indeterminate award of attorney's fees under 19-9-3. However, the court's final order excludes the parties asking for attorney's fees under the specific statute, as the final order states verbatim, mother and father both allege she and he have been forced to incur attorney's fees in bringing and defending this matter pursuant to OCGA 9-15-14 and or OCGA 19-6-2. Both parties will have 20 days from the date of this order to submit the written request of the matter, and the other shall have 10 days to respond. Petitioner, in a valiant effort to communicate with and have access to his daughter, should not be ordered to pay respondent's attorney's fees under 19-9-3. There is no statutory basis for an award of attorney's fees under 19-9-3, as one of the factors determined the best interests of the child were delineated in the court's order as both modifications were denied, and more importantly, the court's final order didn't authorize the parties to seek fees under this specific statute. In fact, the court even stated in the final order, the evidence was clear that the father loves the child and that this is why he has incurred cost of litigation in bringing this action. Petitioner, again, we ask the court to deny respondent's motion for attorney's fee under OCGA 19-9-3 for the aforementioned reasons. OCGA 9-15-4 A and B provides in pertinent part. In any civil action in any court of record of this state, reasonable and necessary attorney fees and expenses of litigation shall be awarded to any party against whom another party has asserted a claim, defense, or other position with respect to which there existed such a complete absence of any justifiable issue or law or fact that it could not reasonably believe that a court would accept the asserted claim, defense, and other position. Attorney's fees and expenses so awarded shall be assessed against the party asserting such a claim, defense, or other position, or against the party's attorney, or against both and such. B, the court may assess reasonable and necessary attorney fees and expenses of litigation in any civil action in any court of record if upon the motion of any party or the court itself, it finds that an attorney or party brought or defended an action or any part thereof that lacks a substantial justification, or that the action or any part thereof was interposed for delay or harassment, or if it finds that an attorney or party unnecessarily expanded the proceeding by other improper conduct, including but not limited to abuses of discovery procedures available under Chapter 11 of this title, the Georgia Civil Procedures Act. As used in this code section, lacked substantial justification means substantially frivolous, substantially groundless, and substantially vexatious. Respondent requests an interminable amount of award attorney's fees under 9-15-14 A and B, but fails to request a specific amount of attorney's fees or delineate what portion of her fees were attributable to such conduct contemplated under OCGA 9-15-14. Fees under OCGA 9-15-14 A and B are awarded in egregious situation. The facts of this case and the court's order in this case do not support an award of attorney's fees under OCGA 9-15-14, nor under Clause B. In cases involving OCGA 9.
Now, I've allowed you to go on and on, sir, but you are beginning to repeat yourself with the argument.
Yeah, I'm sorry.
I want to give you an opportunity to present your
Okay.
argument, but you are beginning to repeat yourself.
Okay, and that may be a function of the bill, so, or the brief. The trial court must limit the fees awarded to those incurred because of the sanctionable conduct. Lump sum or unapportioned attorney fees awards are not permitted in Georgia. And that's a case of Razavi versus Merchant. Again.
Okay, so now that argument's irrelevant at this point because they have asked for a specific amount. So
Yeah.
that
Okay.
part's
Well, Your Honor, I would just refer to the court to the brief. There's much more detail in regard to this. I guess just saying in closing that, in this instant, the respondent continues to play the victim in this manner, and she is obviously quite skilled at playing the victim. She has blamed me for every single occurrence in this matter and even testified in trial that she moved the remainder of my items that were in the house to the shed.
Okay, that's irrelevant. That's an irrelevant argument to this. So let's have a relevant argument here.
Okay. Yeah, I would just ask the court to not to consider fees above and beyond after this brief. And I guess just in closing, both parties in this action had motions to compel against each other, and parties entered into a consent order. The consent order was a one-way street, as respondent alluded to in her motion for attorney's fees. For the aforementioned reason, and I'm sorry, Your Honor, I did repeat myself, I request the court deny the respondent's motion for attorney's fees in order both parties to be responsible for their own respective attorney's fees and cost of litigation. As I mentioned, I've incurred a similar cost, which I can't afford. Just finally, I pray that the court deny the respondent's motion for attorney's fees for the reasons set forth herein, and specifically deny respondent's request for fees under 19-3, as same as not proper, given both modifications were denied and was not reserved in the finals court order. I also ask that the court order both parties to be responsible for their own respective attorney's fees and litigation. I'm sorry, I repeated myself.
No, so you recognize you're repeating yourself, so let's.
No, I'm sorry, Your Honor. Unfortunately, I'm seeing the same items come up. I'm also asking that the petitioner be granted any further relief from this court deems necessary and just.
Okay, thank you. Let me hear from the movement.
Thank you, Your Honor. From the outset, Your Honor, I would suggest that to the degree that it deals with testimony of the opposing party in this case, that his testimony is just not credible. I would suggest, Your Honor, that he doesn't give credible testimony, and he may pick and choose when he so decides to do so. Even in his closing argument, Your Honor, I will point out a couple of things that just demonstrate, just to give a little snippet of what has taken place over the last several years as it relates to this case. For example, on the outset, he indicated that my client has withheld custody from him for more than 3 years. That was pretty much one of the first things he stated, which is simply false. And it's false according to not only reality, but it's false according to Judge Berry's order. Because even in her order from the hearing from June 20th, she specifically found that not only did he get visitation, but my client gave him visitation when he wasn't even entitled to it. So for him to sit here in front of you because you're
Your Honor, I'm where is this documented?
Okay, hold on. What's your objection?
I'm objecting based on relevance. I'm not even sure that these facts are correct. I think ultimately the order that was put forth speaks for itself.
I'll overrule the objection. Go ahead.
Your Honor, like I was saying, in Judge Berry's order, he specifically found that my client gave him visitation when he wasn't even entitled to it. So for him to say in front of you today how he's been withheld visitation for 3 years is just another example of his not being credible. Also, he indicated on the onset of his statements, his closing argument, that his attorneys, they waited for more than a year to even file the contempt that's in place. Well, Your Honor, the reality of it is they filed it on June 2nd, 2021. But the order of which that they're claiming that was in contempt was from a final divorce decree that was from April of 2020. So best case scenario for him is that as soon as they walked out the courthouse doors, he wanted to file a contempt, but his attorney said no and waited for more than a year before they did so. I would suggest to you again that those just two examples of blatant examples of how his statements are just simply not credible. Things that he has said to you within his closing argument. Now, Your Honor, big picture of this case, I would suggest, we are asking for fees under 1993G, which we believe Your Honor has the ability to do, and it's discretionary, and it's based upon fairness and equity. We're also asking under 9 we're asking under 91514, because the reality of the situation, as his petition should have never existed. He filed a petition for custody modification and contempt. He filed a petition for custody modification when, according to him, he doesn't have a residence, but we beg to differ to some of that. And also, according to him, he never even provided an address. All these years, never provided an address as to where he's taken the child. That's one of the reasons why my client had to file something. So he wants to take a child out of state, never provided an address, and it's a whole litany of issues that occurred even before in the divorce that are associated with this case. So, Your Honor, this case should have never been filed. And then on the contempt issues that he filed on, Your Honor, things were just blatantly false. For example, on count 1 of the contempt, he indicates in the time he filed that the reason why he has to file is because mom has withheld the child from his summertime visitation. He actually filed that mother, my client, was withholding the child from him when the child was actually in another state with him at the time he filed it. It shows that it was just totally false. And he also indicates that mother, in count 2, that he withheld his visitation from spring break. He wasn't entitled to any visitation at spring break. And the court's order points these things out. It was just totally false. The things that he has said, the things that he has pled in this case were just totally disingenuous and false. Some of the other things that were just totally false is he said that one of the issues in the contempt was that there was supposed to be, my client were to help him to obtain COBRA, or provide the information so he can obtain COBRA. And he made a contempt count of she never provided this information. Well, again, once we're in court and it comes out, it was just totally not true. She had provided them this information on at least 3 different occasions. Then he made issues.
Your Honor, there's no evidence of 3 other occasions. I object to this.
Okay, the record will speak for itself.
And then, Your Honor, he made an allegation in his contempt that she failed. They were supposed to split marital equity in a home. And he made an allegation that she's in contempt and she got to defend all these things. All these things cost. But that she did not give him his marital equity in the home. I don't even know how someone can plead these things because they're so false. But the reality is, the attorneys at the time, they worked out an agreement where he never voluntarily paid child support. So his marital equity in the home was offset by the child support. And that was agreed to far in advance. I mean, we even have a document signed by the attorneys on this situation that came out during the trial. So my point is, these things were just blatantly false. They weren't even, they weren't a tomato type of issue. He did things and pled things that were just not true. And it created so many different things. He also indicated that he failed to transfer funds from a 401k account. Well, the reality is that he was supposed to get a quadro done, and he never did. In fact, he tried to force my client to get a quadro, knowing that—
Objection, Your Honor. Objection, Your Honor. I never
What's your
forced
objection?
anybody to. This is such a mischaracterization of what the facts were. There were no facts that I forced her to get a quadro. That just simply is not true.
Noted, the record will speak for itself.
Your Honor, on the quadro issue, he was supposed to get a quadro done, and he kept trying to say that my client was going to get—
Objection, Your Honor. The record should speak for itself. A quadro attorney was hired by me,
Okay,
and
so
his
again, we're not gonna
actions.
litigate it. It is, I guess, subject to proper argument. But he is able to argue it as part of his basis for requesting the fees. So
Okay.
So, Your Honor, the bottom line is that with this quadro, he never did it. My client was the actual one that hired an attorney and actually hired it on her own to get a quadro for him. But yet he pled that she refused to cooperate. And even though he claimed that he hired an attorney, there was not one shred of evidence in any way, shape, form, or fashion that even remotely suggests that he actually did that. All his things are statements that are coming solely from his mouth. But the bottom line is, at the end of the day, my client is the one that not only hired an attorney to do a quadro and paid for it herself, but in addition to that, when presented to him, he refused to sign it. Just further delaying things, further incurring attorney's fees, further making this whole situation overly litigious. At the same time, they filed, in addition to just the count of the petition for modification and contempt itself, at the same time, they also filed a motion for expedited hearing because they had to get visitation, because it was an expedited hearing because the child was going to miss his summer parenting time with the father. Well, first of all, as the court order indicates, the child was never entitled to summer parenting time with the child in Ohio, as the court order indicates from Judge Berry. Second of all, while they filed this motion for expedited hearing and while all the back and forth is going on and all these attorney's fees are associated with this motion, the child is with him. They filed a motion for expedited hearing so he can exercise visitation that he's currently exercising. These things were just disingenuous and false. Then, when they finally filed a withdrawal for the expedited hearing, it was only after they knew that a motion for attorney fees were coming. So they filed his withdrawal for expedited hearing, and on the same day filed a motion for a psychological evaluation against my client with no basis at all, just creating things. So my point is, all of these different motions were created, all this different types of litigation was created and generated fees and generated expenses that had absolutely no basis or legitimation at all. At every step of the way, he failed to cooperate. Even to this day, he hasn't made one voluntary child support payment. Even after the court's order from June 20th, he made a lump sum payment, and that was only because it was right there in court. And then he hasn't made a payment since. And not once has he made a payment.
Your Honor, I'm just objecting to this. We're back to kind of shoehorning a contempt into a motion for attorney's fees. This information is not relevant to the argument for attorney's fees.
Okay, response.
Your Honor, this is totally relevant because everything that occurs is generating attorney's fees unnecessary because he's failing to cooperate, he's failing to act in good faith, and he's constantly making statements to the court and pleading.
Your Honor, I object
Okay,
to this.
so hold on. I sustain the objection to the degree you're going beyond the final hearing. So I would sustain it. Please move on.
Your Honor, also, in addition to that, they filed motions to compel that had no legitimation whatsoever. They did not comply with our I wasn't the attorney at the time, Your Honor. For the record, just in case Your Honor don't know the timeline, I got on this case approximately April of 2023. But at the time, this case has extensive litigation. There were a lot of different things filed, but he failed to comply with discovery. A prime example, he hasn't even provided an address. Up to this day, How can any reasonable person
Objection,
file,
Your Honor, this.
Okay,
it's
I'm
just-
sorry, what's your objection?
My objection is this is false. It's stated in the final order. I was asked during the trial what my address was. and
Okay,
it was
so you
provided.
object on the grounds that it misrepresents the record.
Misrepresents
Okay, the record will speak.
facts that have already been
Okay,
presented
so
during
hold
the
on,
trial.
hold on. The record will speak for itself on that.
Thank you, Your Honor.
and even during the trial, when Judge Berry asked him for his address, he was evasive. And even today,
Again, Your Honor, objection.
Okay, what's your objection?
The objective is that he's just repeating the same thing over and over again, and the record should speak for itself.
Okay,
There-
I'll
there's just
overrule. He
a
is commenting
mischaracterization.
on evidence that was presented again today. So I'll overrule, but I would ask you to, as I indicated earlier with him, please don't repeat all of this
Okay.
over and over again.
I'm sorry.
No,
Thank
I'm speaking to Mr. Pepakali. Please don't
Okay.
keep repeating this over and over.
understood. The point is, Your Honor, with the discovery process, everything he failed to comply with, that made things litigious. The address is just an example of that. The same way with his income information and his working information. Everything was pulling teeth. As a result, it created fees. And I would submit to Your Honor that under 19,
Yeah.
Do you have an objection, sir?
Yeah, I mean, I'm objecting. I don't even know where half of this information is coming from. I think the record speaks for itself. I don't think there was anything, again, the address was provided. You keep mentioning it over and over again. And secondarily, I don't know of this instance or if there's any evidence of where I've refused to provide any detail about my income. That's completely false.
So overrule. You may continue.
That's why there were motions to compel. And that's where those motions to compel. So motions to compel have been filed. 6.4B letters have been filed. These motions, such as motions for expedited hearing and motions for psychological evaluation that had absolutely no merit were filed. All of these things were filed. We had a 2-day trial defending things that didn't even exist, such as the various issues that were outlined that I indicated in the counts that was just purely false. And then the other count that was just things that were made up that you wouldn't be able to point to being purely false, but I would suggest that the evidence shown that they were not credible, and that's how the court ruled on them. Now he hangs his hat on that both were found in contempt. The idea of the contempt is just is apples and oranges. Ms. Toka was found in a technical contempt by the court because she didn't give him the child's phone number when he asked, because he just simply said, ask the child, because of his actions towards the child. And she just said, ask the child.
Objection, Your Honor. There was no evidence. Objection, Your Honor. There is absolutely no evidence reflecting what he's saying. Objection. You're mischaracterizing evidence that didn't even exist.
Okay, I'll overrule again that the record speaks for itself. It's a proper argument, but any discrepancy in what was fact and what is argued will be resolved by the record itself.
Thank you, Your Honor. So Judge Berry determined that as a parent, she shouldn't have said, ask the child. She should have just given it to him regardless and not put the child in. And that was the level of her contempt. But his contempt was all of the above. And they were all blatant and they were all obvious. So it was no contempt of her withholding the child or doing anything or using the child against him. None of that was found. And
it seems like the big sin, little sin sort of argument. Is that what you're arguing?
What we're saying is that because of the context and the historical context of how he reacted towards my client and the child, when he asked about a phone number, she said, ask the child, and she called herself not getting in the middle of it. Judge Berry ruled that she shouldn't have done that, that she should have just provided. he ultimately provided. He got the numbers. He gave it to him. But that was the basis. It was like a technical contempt. It wasn't. It wasn't an ill will type of issue. I would suggest to Your Honor. But nevertheless, my point is that was the basis of the contempt. It wasn't a contempt. She wasn't found multiple counts of contempt. There was one count of contempt she was filed. It's in the order. And the bottom line is he was found in contempt on everything. And the only
Objection.
What's your,
I was not
what's your
found in
objection?
contempt on. I was not found in contempt on everything. That is a gross mischaracterization. The facts don't even represent what you're saying. I was not found in contempt on everything. The motions failed.
Your Honor, the order speaks for itself. He was found in every single count of contempt that was filed against him. It was 4 of them, and he was
Okay,
found
please
on
move
all
on.
4.
Please move on.
So Your Honor, all of these things, this is a very litigious case, and all of these things occurred, and the case had never even been filed in the first place. As a result, because of 1915-14, we can attribute a direct amount of fees that are associated with this case. And we're asking ultimately that a total amount of fees should be awarded in the amount of $73,906.51. And of those fees, Your Honor, I would suggest that a total of $68,220.30 are for attorney's fees. And then there is $5,686.21 that is directly attributed to the fees associated with the tax issue that Her Honor specifically put in.
Objection, Honor. This is what he's asking for is outside the scope of anything after the trial.
Order,
Okay.
Your Honor.
Okay, so again, this is for the attorney's fees only.
Well, Your Honor, we were asked for solely for attorney's fees is $68,220.30. And we were asked that those fees be awarded pursuant to 1993G and or 9/15/14. We can also associate an exact amount of specific billings of $48,680.30 specifically to issues associated with 9/15/14. My overarching premise is that all of the litigation was unnecessary. It should be subjected to 9/15/14. But there are specific entries that we can specifically identify as to either the such issues as unjustifiable delay, bad faith, or just false allegations, defendant things that were false, such as the motion for expedited hearing, things that was just not true. And that, like I said, number is $48,680.37.
Okay, is that it?
If I can have 1 second, Your Honor. Your Honor, overall, that is it. I appreciate the time and listening to this case. But again, as I indicated before, that the bottom line is the issues that he did that were just not true, related to the quadro, related to the expedited hearing, issues related to attorney fees, the discovery abuse, the motions that should have never been filed, such as motion for psychological evaluation, the motion for expedited hearing.
Now, again, you're repeating.
I am, and I'm just summarizing it, and those issues all contribute to a justification for the 9/15/14 fees.
Now, based on what I'm saying, your client had 3 or 4 different sets of attorneys.
He had 3 attorneys,
Prior to you or including you?
including me, I believe. That would have been Aaron Thomas Law. It would have been Heridia and Lennon, and then it would have been Hedgepath Heridia.
Okay, all right, thank you. Well, that concludes the hearing. I am going to request that both sides submit proposed orders to the court. I'll give you the same time frame as I gave the earlier party, December 1st by the close of business. And please forward those to the court in an editable format. Thank you.
Thank you, Your
Okay.
Honor.
Thank you, Your Honor.
Thank you. And I'll ask the judge's staff to just remain briefly. So
May we
everyone just may log on. Thank you.
Yes, ma'am.
I'm sorry, Your Honor. Am I free to go or were you just?
Yes, you're free to log off. Thank you.
Thank you again, Your Honor.